Okay, hello everyone. Thanks for joining us today. We'll get started straight away here. I am Sharia Ali. I am the SLP advisor at AXLPA, and today we're talking all about informed consent. We're doing things a little bit differently today. We don't have a new guideline or other practice document that we're wanting to make you aware of. But we know that this is a very busy time with a lot of folks going back out to school, and informed consent is a big issue. I've already gotten lots of questions in the last 2 weeks about it. So we thought today might be a good time to just provide a refresher on informed consent, what our standards and guidelines say, and some best practices. So thank you for joining us again. I know this is a very busy time for a lot of folks. I think I saw a school division group in the participants today. So shout out to them and to anyone else who's back at work after a summer off. So before we get started, just some quick housekeeping notes. You'll notice your camera and your mic are turned off. They're actually going to stay off while I'm presenting the slides. It's just easier for us to manage that way. The chat's available to you during the formal presentation. You can put any questions or comments in there as we go along. I try to monitor the chat as I'm presenting and respond to questions when I can, but if I don't get to it in the moment, there's going to be a question period at the end, and I'll answer all questions then. We're going to be recording this presentation, and the video and the slides will be made available to you. In about a week's time, participants will get an email saying when that's ready for access. On this slide in red, you'll also see a helpline if you're having technical issues and if the chat isn't available to you. Give us a call or an email and we can help you troubleshoot. So today we're going to start off by covering the basics of informed consent as per the AXLPA standard of practice and guideline on informed consent. Then I'll discuss a bit more about how we can better meet the ethical requirements for informed consent. And then I'll go over some scenarios that I get a lot about informed consent. And as I said, we'll have time for questions at the end. So to start off, we're going to do a quick recap of the information in the informed consent guideline and standard of practice. It's linked in this slide, but Paul, if I can get you to put the link to, oh, it's already there, thank you, to the guideline on informed consent for service. And perhaps on the next one, we can also do the standard of practice. So first off, it's important to note that obtaining informed consent is, in fact, a minimum requirement of practice. So we're not just doing it to be nice to our clients. It's not just for funsies. AXLPA has a standard of practice on informed consent. It's linked on this slide. And informed consent is also a foundation of ethical practice, as per our code of ethics and the bioethical principles that it's based on. So informed consent underlies the ethical principle of autonomy, or the right to choose or decide for oneself about one's life. It's linked to the principles of beneficence, which is acting in ways that benefit others, and non-maleficence, acting in ways that bring no harm or negative consequence. So while we all have professional expertise and training, ultimately, the decision about what's good or what's harmful for a client can only be made by the client themselves. So one way we support this decision-making about what's good or what's harmful is through the informed consent process. Now, because informed consent is so foundational to ethical practice, there can be significant implications for the client and their well-being, and also for the regulated member and their practice if informed consent isn't handled correctly. So the next few slides are going to be looking at sort of the take-home points from the guideline. So the first is what informed consent should cover. So on page 3 of the guideline, you'll see a list of considerations for informed consent, which are also shown on this slide. So these points have to be covered irrespective of communication mode. So whether that's face-to-face, person-to-person, via telephone or email, or within any documents that a client is required to sign. So I just wanted to flag this one here for you, talk about consequences. And just because I want to flag that in some cases, you will need to discuss with clients the consequence of what accepting a service may look like. It's important, especially I think in consent for assessment, because in many cases, as we know, assessment is going to produce actionable findings. And knowing what they may find out and what next steps may be required may help some folks decide whether they want that information in the first place. So let's take a seemingly simple example of a hearing test. Consenting to hearing testing may result in the identification of a hearing loss, which then may result in discussions about intervention options, which a client may or may not be ready or willing to deal with at that time. So as health professionals, we know assessment leads to findings, leads to interventions being required, but some clients actually may not be aware of this. So it's important that they are made aware of any consequence to accepting services, what might be required of them later on or expected of them later on. So this can, of course, get more complex in some situations. For example, swallowing concerns where assessment might lead to changes in the client's diet or even non-oral feeding options being discussed. And so I'm also going to flag this item, opportunity to ask questions, because I know some modes of communication can make this tricky. So the client has to be afforded this opportunity, though, to seek clarification, get answers to their questions so that they can make a choice. So if you're having clients sign a form or if you're communicating via email, you will need to ensure that clients are aware that you are available to answer any questions that they might have. So next, who can provide informed consent? So informed consent for service must be obtained from the client or a legally authorized representative for the client. So a couple added considerations to this. The client must have the capacity to provide consent. That is, they must be able to understand and make decisions based on the information that's presented to them. And then a reminder here that capacity has to be presumed and that ACSLPA regulated members are required to make reasonable judgments in this regard. Where there are concerns, you have to request a capacity assessment and monitor the results of that assessment over time. So I've just linked on this slide the ACSLPA position statement on the SLP rule in supporting capacity assessments, which can provide more information on this. Another consideration is following client wishes around their involvement of others in their care and making decisions about their care. So I'm actually going to be coming back to this point in depth a little later on. So we'll leave it for now and we'll come back to it later. So informed consent is required prior to any professional service, which may include, but it's not limited to the services shown on this slide. You'll also need to update consent in a timely manner whenever there's a substantial change in the plan of care, diagnosis, symptoms, etc. So typically, the professional most responsible for the provision of care is responsible for obtaining informed consent, as this person is in the best position to answer any questions. Now, because we know that it's sometimes not feasible to expect that, we say that certain aspects of the process can be performed by others. For example, distributing and collecting an informed consent form. But we should note, assigning procedural steps does not absolve a regulated member from working to ensure that consent is informed. So regulated members should review any information that's being sent out about services and ensure that clients know that they are available to answer any questions. So there are also a number of considerations around how informed consent should be obtained, and these are shown on the slide. So I'll briefly touch on some of them. So first, if you only take one thing away from today, I hope it's that obtaining informed consent is not a one-time event like signing a form. It should be an ongoing collaborative communication process and one in which the client feels comfortable and empowered to participate. I also get a lot of questions about whether consent has to be written or whether the client has to have a form that they sign. So while having something written down may be considered proof of the process, there's no preference or precedence between verbal and written consent. So verbal consent must be documented, but it's equally as applicable for as proof of consent for documentation purposes. So, So we've just quickly run through the basics. And again, you have the guideline to kind of, to turn to if you need to refresh on any of that information. The next part of this presentation, I just wanted to delve a bit more into factors that impact the informed consent process. So actually, I wanted to start off by actually highlighting the various purposes of informed consent, because there are actually a number of things that professionals are having to keep in mind all at once when obtaining informed consent. So informed consent, of course, has a legal purpose, specifically client protection. So it provides a legal structure or framework in which clients are protected from unwanted, harmful, or unnecessary procedures. So we're all probably aware of terrible instances in the, in healthcare where the informed consent process wasn't applied, like the forced sterilization of Indigenous women. So having strict requirements for informed consent, like an ATIA standard of practice, like in all the other colleges, the standards of practice, it provides a mechanism of, sorry, I'm getting a phone call. Ignore that. Yes, so having strict requirements provides a mechanism of legal protection for clients. So there's a legal obligation on the provider to provide clients with the opportunity to exercise their autonomy, make decisions about their own care and their well-being and their lives. The documentation of informed consent also has an administrative purpose. So it proves completion or compliance with those legal requirements. And as we talked about in the first slide, informed consent also has an ethical purpose. So it ensures that the client is provided opportunities to exercise their autonomy and to make decisions about their care. Now, from my experience as SLP advisor, I think there's a lot of focus on these two, the legal and admin purposes. So I get questions around, what's the minimum requirement and how do I prove that I'm in compliance with those minimum requirements? It's not bad questions to be thinking about, but today I really want to prompt us all to start thinking more about the ethical component, that client experience, a client perspective, and how best we can ensure ethical decision making on their part. Because delving into the research actually showed me that the theoretical ideals where all three purposes are met, that actually rarely happens. And in fact, it's the ethical purpose that's the most difficult to meet. So there are a number of factors impacting the process and whether all three purposes are met. So I grouped them into client factors, provider factors, and other factors. So let's just quickly take a look at those. So in terms of client factors, of course, factors such as age, capacity, level of education, which then impacts health literacy, they're all going to impact how a client is able to exercise their autonomy. So for example, think of a teenage client who can't be deemed a mature minor, but they disagree with a treatment that their parents want for them or have consented to. Or a client who's just not familiar with what an audiologist does or what an SLP does, and they decline or consent to services when they don't really understand what it means. Clients' physical and mental states also impact their ability to process information and make decisions. So I don't think there's anyone here who would say that they make better decisions, faster decisions, more rational ones when they're stressed, overwhelmed, or in pain. So, for example, think of first-time parents who hear the words hearing loss about their newborn and they just go into a panic state. Or the children of a stroke patient dealing with the stress of having a parent in hospital. Client decision-making preferences can also be highly individual. So some clients may want to delegate a loved one to make decisions for them. That helps, bearing the emotional and mental burden of processing information, making decisions. Some clients might also want and expect from a therapeutic relationship that the expert makes decisions. So think of an elderly client who is getting really frustrated with a provider who keeps asking them, well, what do you want to do? When they're thinking, I've come to you for you to tell me what to do. Something else I think is really important to mention is that clients can and do consent to services, even when they don't fully agree, to avoid offending their provider. So as healthcare providers, we are in a position of power over clients. We do have control over the care they receive. So very understandably, they can be sometimes a very real perception from clients that disagreement with their provider may negatively impact their current care or even their care in the future. For example, a parent who's being supported by Children's Services who may want to decline in-clinic speech therapy for their child because they can't afford the bus tickets, but they agree to come and they take on that burden because they're worried that a refusal might be reported to the social worker and then used as a reason to apprehend their child. And that's actually a real life example from a past client of mine. So just from all the brief examples from this slide, we can see that there are many permutations of client factors that can make the informed consent process complex. And we're going to add to the complexity the factors that affect providers when they go to obtain informed consent. So everyone here probably well aware of the demands on their time, including a very quick turnaround time that's expected to obtain consent. So being in a time crunch can impact how much and just how information is shared. As I mentioned on the last slide, it's important to also be mindful of the power dynamic between yourself as a healthcare provider and the client, so that you approach informed consent conversations sensitive to how the client perceives that power dynamic in your relationship. You should also be mindful of communicating information in a way that facilitates understanding. And we also have to make very quick determinations of how a client wants to be involved in decision making. So a provider's skill in these areas will impact whether the ethical requirement of informed consent, allowing for client autonomy, is met. So there are other factors that impact the informed consent process that they're more inherent to the situation rather than to the client or the provider. So the first is the assumption that clients are going to use the information presented to them in rational ways. And by rational, I just mean in the way that a healthcare provider might think is rational. So the general assumption is that a client is going to make a decision that's in their best interest for their health and their well-being. Anyone who's been around humans will know that that doesn't always happen. So our job is not to strong-arm a client into a decision, but we do have to leave room for situations where a client just doesn't see the situation in the same way that we do as healthcare workers. We also need to be mindful of the fact that in some situations, there may not actually be much of a choice for the client. For example, a head and neck cancer patient, severe dysphagia, consenting to swallowing assessment and intervention. So you still need to share the same information and gain consent, but it's important to take care in how information is shared in these types of situations so that the client doesn't become frustrated or upset by being asked to make choices that to them seem pretty obvious. A client's communication and information needs may also vary with the type of proposed service. So for example, lots of schools use a mass distributed consent form, and that can suffice for a speech and language screening. It's more routine, it's non-invasive. However, you'll probably be wanting to have more in-depth person-to-person discussions with a client who needs a fees assessment. That's an invasive procedure with risks. Situational factors like the availability of language or culturally sensitive supports for the client, and just also the time that they're given to make decisions can impact whether an informed consent process meets its legal and ethical objectives. So in light of all of those confounding factors, I just wanted to share some strategies from the literature about obtaining informed consent in ways that are in line with that ethical purpose, ethical requirements of consent. So the first is to make sure that the process of decision-making is in fact shared between you and the client. So remember from that earlier slide, consent is intended to be a two-way, collaborative, ongoing process. It's not a one-time event. Next, even though our legislation really stresses individuality in the decision-making process, that consent must come from the client, I think there's space to involve any others that the client wants involved in their care. So we can't underestimate the value of reducing a client's decision fatigue and emotional load, particularly when the diagnoses are difficult and complex. So let clients know support people are allowed to attend with them. Pay attention to the cues you get from people in the room, or just ask how the client would like their support people to be involved. As I've been alluding to, the informed consent process shouldn't be a one-size-fits-all approach. So clients will differ in the level of detail they want, who they want with them when they make the decisions, and just their goals for themselves and their well-being. Depending on the client, even the day or the time, their physical and emotional states may impact their needs during the informed consent process. There may also be cultural or societal norms to be mindful of. For example, an older client in some family systems may expect and want their adult children to be the main point of contact when they need care and to be the decision makers in their care. Or some folks might not be comfortable okaying something for their child without first speaking to their spouse or even their parents. So making all these determinations and adjusting your approach to suit may take some extra time, but there really are ways to satisfy yourself that your consent is informed. I think that first jargon-free strategy is super important. Just carrying on with some of those strategies to consider. Because consent forms with complex legalistic language just really seem to be the norm now. So while using this type of language and having folks sign at the bottom fulfills the legal purpose of consent, we can't be sure that the ethical component is met when the words on the form itself are a barrier to people reading it. A lot of these forms require a very high reading level, and even if you have that reading level, the complexity and the length of the form might just turn you off from reading it anyways, and you just go ahead and sign without reading it. One thing that I thought was really interesting from the literature is making sure that the client understands what they have a choice on and what is considered a condition of service. So that is what is sort of non-negotiable once they've agreed to services. For example, in one of my previous workplaces, services were offered so that if you consented to SLP services, that meant that your child would get classroom services, but you were also sort of agreeing upfront to a certain number of home visits. And I don't know that the home visit piece was made super clear to guardians and parents, that was a condition of service. The expectation is that the home visit must happen. So it's really important to make those sorts of distinctions clear. As the people who offer these services routinely, it might be clear in our mind, but for someone who's accessing a service for the first time, they might not be as clear in what the format is, what's expected. Another point to think about is how much time we give clients and their supports to process information and make decisions. So I know this is a direct result of the pressure on professionals to get things done quickly. But if you do have the flexibility to offer more processing time, particularly if your work involves like complex, higher impact diagnoses, this could be a strategy to implement. So related to that last point and the first point on this slide is making sure that you include other supports or resources for decision-making for the clients. So is there a pamphlet they can take home and read that would be helpful? Is there a website or an organization that you know of? Where they can get good and accurate information? Is there a visual aid you can print out for them? All these examples may facilitate understanding and help you to feel more secure that the consent you receive is informed. And you'd also want to make sure that informed consent is supported for clients who need accommodations. So clients with low health literacy, how can you best support them? Is there someone else that's better placed, like a social worker or a community support worker, that can help them navigate services? Do you have accommodations in place for folks who don't speak the language of their service provider, or for folks who need any sort of accommodations to see or sign a form? So keep all of those factors in mind, because we're now going to turn to some frequently asked questions I get at AXLPA about informed consent. So first one, probably most common for me, I get this a lot from school-based SLPs, when they're asked to have like some sort of involvement with a student who's just not on their official caseload. For example, being asked to just listen to a student to confirm the teacher's observations, or to have a student join a targeted language group session because the teacher noticed they're having the same difficulties. So while working in a classroom setting can make it seem like your services are a probable and expected part of classroom services, As SLPs and audiologists, you are healthcare providers, you are regulated under the Health Professions Act, and as such, informed consent is required prior to any individualized health services you may offer. So when I say individualized, you have a specific client that the services are offered to. So if you could put a face and a name to what you're doing, that's individualized health services. So that includes screening, observations from which you'll make clinical impressions, activities that are planned based on treatment objectives for other students on your caseload. So remember that legal purpose of informed consent, to provide a framework in which clients can refuse unwanted services. We have to provide that when offering health services. So if you're asked to provide individualized services for students that aren't on your caseload or for clients that aren't on your caseload, you will need to get informed consent. So in some school settings, you can check to see what's covered in the general classroom consent form if your school uses one, but you will need to take some time to figure out what you have consent for and whatever else needs to be communicated to guardians. So you can't just jump in. So part of managing the situation may be communicating just that. Maybe that you have to communicate with your teaching and admin staff that there are strict informed consent requirements for your profession. So you're not going to be able to comply with a teacher's request to involve a student that hasn't been assigned to you right as soon as they ask. So to them, it might seem like a very simple ask to let little Pedro join a vocab group or to give him a turn with someone else's AAC device. But if Pedro's guardians were to find out that an SLP was working directly with their child without their consent and knowledge, there could be serious consequences. So another question I get frequently is who can give consent when the official legally authorized representative for a minor client, like a parent, isn't available, and when there's not a formal guardianship order in place for the person who's actually caring for the child. For example, situations where a family member or a friend looks after a child when the parent can't without involving children's services, and then when the provider just isn't able to contact the parent, who on file remains that legal decision maker for the child. So in these types of situations, it's important to note that current legislation doesn't really take into account these different types of family systems. So systems where informal guardianship is an important family support mechanism. Some folks might not pursue official guardianship from the government for valid reasons, historical forced family separations, or perhaps they go into it knowing that it's going to be temporary. What the law says, though, is that consent must be obtained from the legally authorized representative for the child, so we have to work within those boundaries. So in these situations, you could check to see what's already been consented to, stay within those limits. If this is a situation that comes up frequently, you may also want to consider working with your employer, if applicable, to develop a policy for obtaining consent in these circumstances. And someone with expertise in family law that can give legal advice on that is probably going to be the best source of general information on how to proceed in these cases. So seeking legal advice is recommended. Something else that comes up a lot is consent to share information within and external to organizations. So if you have a question around, am I able to, share information on a client with another provider, another professional? The first step in getting the answer to your question is figuring out which pieces of legislation govern your practice setting. So some examples are shown on the slide on the bottom. And basically, they all control what information can be collected and how it can be disclosed. So this isn't an exhaustive list. There are other pieces of legislation that may apply to your setting, like the Child, Youth, and Family Enhancement Act or the Protection of Persons in Care Act. So each piece of legislation highlights certain situations where information can be shared without consent of the client, but generally they require that consent is needed to share client information in most situations. So AXLPA doesn't administer these pieces of legislation, but regulated members are accountable to adhering to all relevant legislation. So what that really means is that your employer's legal department or the privacy commissioner even will be the best source of information if you have questions about tricky consent to share information settings. Something I realized just this morning was that for most pieces of legislation, there's actually a help desk. So I put a link on this slide just as an example. So hopefully you're seeing information on FOIP on your screen. So if you just Google like FOIP or PIPA or ATIA Alberta, it'll take you to a Government of Alberta site that has more information on that piece of legislation. And importantly, there's a contact tool that you can use. So yes, so click on that. They can help you navigate that piece of legislation. So FOIP and PIPA are together. They have the same help desk, and then there's a separate one for the Health Information Act. So they don't offer legal advice or interpretation, which is not what AXLPA does either. But if you have a question about specific privacy legislation, you can contact the help desk for that piece of legislation. Same as you would to contact AXLPA if you have a question about, hey, what does the standard say about this? So something else that comes up from members is whether informed consent has an expiry date or whether you can put an expiry date on informed consent. So when we think about the legal and admin purposes of the informed consent process, if you get a client to sign a form which has an expiry date, or if you have a workplace policy about renewing consent after a period of time, then a legal framework has been created where consent expires and needs to be obtained again. So clinicians should follow the procedure that's been created. However, there's no college guidance, there's no AXLPA guidance that says that consent expires after a certain time. So what the college does say is that consent must be updated whenever there's a change to services, and also says that informed consent is a dynamic, ongoing collaborative process. So from a college perspective, consent needs to be updated as needed throughout service provision. And also, I think it's just a good practice to keep clients or their guardians informed of what's happening with their care. So I also get some questions about negative consent. That is, if the absence of a response for consent can be interpreted as consent for services. For example, if a school-based SLP leaves a message to inform parents that a new assessment needs to be completed and asks them to call back if they have questions, and then they never hear back, can the SLP assume that this means that parents don't have questions or that they consent? So it might be tempting also to put on forms that consent is assumed unless guardians let providers know otherwise. So there may be many reasons why a guardian or decision maker doesn't get into contact. So we shouldn't assume that the absence of a response means that the client consents. A form could have gotten lost on the bus ride home. Parent could have been meaning to call, but they just forgot with all their daily stresses of life. There could have been an emergency. So having wording around negative consent being accepted might fulfill the legal purpose. So it's documented, you told the client to let you know if they refuse services, and then they never called. So you might think, oh, I've covered my bases there. But remember, we also have an ethical obligation to satisfy ourselves that the client made an informed choice, and we can't do that with negative consent. So I think that was actually my last content slide, just some references here that I used. And so we'll get to questions. Thanks everyone for attending, and we will see you at the next webinar.